to the accused person and that the same has not been objected to, that the prosecution have not demonstrated the disharmony or the breach of peace that is being alleged, that the affidavit seeks an omnibus incarceration of all the 23 respondents who are to be held in custody for 14 days pending investigation, but the same is arbitrary and an abuse of the court process. And amplified by the DPP seeking from orders that the 23 respondents of the court is detained for 14 days to enable their applicants. That is the DCI sent to Nairobi to complete investigation. They have relied on the grounds on the face of the application, together with the supporting affidavit, sworn by Corporal Anthony Kerini. In brief, they state that the 23 respondents were arrested in Nairobi CBD and that they were booked by Central Police Station, that an OB was provided for receipt, that the mobile phones of the state suspects were taken and that are to be subjected to Communications Authority of Kenya, that they are to extract messages, WhatsApp messages, Facebook, X messages, photo taken that are inciting to members of the public against the state. That they are yet to obtain CCTV footage, record witness statements, and that in the end, should they be released and continue to disrupt peace and tranquility within the country, and that they are a threat of peace and stability. We had many counsel appearing for the respondents. They have given their response. Among them, they have quoted sections of the Constitution on the rights of the accused person. They have also raised the issue on conditions of the accused persons who have been arraigned before this court. They have also stated the law on what is to be considered for the grant of bonds, which is compelling reasons for the court to consider. They have raised the rights of an accused person to picket and to hold a peaceful demonstration. They have also raised an issue that the affidavit that is before court does not disclose any offense, but they are mere speculations. That the investigations to be carried out do not require the presence of the accused person, and that the court has the discretion to grant both bail and bond to the accused person, and that the same has not been objected to, that the prosecution have not demonstrated the disharmony or the breach of peace that is being alleged, that the affidavit seeks an omnibus incarceration of all the 23 respondents who are to be held in custody for 14 days pending investigation, that the same is arbitrary and an abuse of the court process, that the investigations are already prejudiced, that court orders were not obtained to extract information from the said phones belonging to the respondents, and that the court has to balance the rights of the accused person while looking at the said application. In my analysis and having heard all the submissions that have been made by the prosecution and the defense, I have considered the law, the issues that have been raised. I have also considered the nature of the offenses that have been stated in the said affidavits. I will agree with the defense that the same are misdemeanors. I have also looked at the said application and the number of days that is being asked for, which is 14 days. The prosecution in stating, making a request for the said date, has also stated that there are some aspects of the investigations that will not require the presence of the respondents before this court. This has been raised by the respondents' counsel. The issue of the CCTV cameras, recording of witness statements, will not require the presence of the accused persons in custody. More particularly, what has been stated was that the accused person are a threat to breach of peace. Therefore, from the evidence, from the material that has been placed before me and the law, looking at the compelling reasons, the court has looked at what has been submitted and agree with the defense that the court has to balance the rights of the accused person while granting the orders that has been sought. In considering the nature of the cases that the IO wishes to investigate, the court also considered Article 29 of the Constitution, which provides for the rights and freedom of the accused person. It states that every person has a right to freedom and security of person, which includes the right not to be deprived of freedom arbitrarily or without just cause. The same should be done without, if the same is done without trial, the same should not be done without trial except during a state of emergency, in which case detention will be subject to Article 58. Article 24 of the state constitution also on the rights and fundamental freedom on the Bill of Rights shall not be limited except by law. Therefore, in my analysis, so far as the bond and bail is concerned, there must be compelling reasons not to grant the same. The court board promotes values that underlie the open and democratic society based on human dignity and equality, equity and freedom. It therefore follows that the function of bail is to ensure presence of accused person to attend the trial. Be as it may, the nature of the offences as stated does not disclose or warrant detention of the respondents. The state have failed to prove that the investigation will call for limitation of respondents' liberty and require them to facilitate or conduct investigations. However, I would wish to point out that justice demands thorough investigation, and at the end of the day, if investigations reveal that the respondents are not culpable, justice will have been served, and the course of justice therefore will not be a smooth ride. And based on that, I will allow that I'll make the following orders: that the 23 respondents hearing will be released on bond. I hereby grant them a bond of Kenya shillings 50,000 with a surety of similar amount, each one of them. 5,000. I will also direct that we report to the pending investigations. We'll mention the case after 14 days.
We appreciate the ruling of the court and before senior council will say anything, I just want to point out one thing. It is the 31st of December 2024, meaning that tomorrow will be a new year. Just on that basis and on the basis of humanity, and I have spoken to my colleague from the DPP, as we welcome the ruling, I am making an